with that, I have the immense honor of introducing our first panel of speakers. So I don't know if we're going to get walk-on music because we're having technical issues, so I'm just going to introduce them. So first, from the Institute of Justice, we have Ben Field.
Teach a course in funeral and cemetery law and study the laws regarding the status, treatment, and disposition of human remains. So Isabel mentioned a little bit about what I wanted to talk about real briefly, since this is a legal panel, so we're going to talk about law stuff. So I wanted to start with sort of walking through the structure, the legal structure that governs the funeral and cemetery industries in the United States, because I think it's important to understand how that structure works if we want to talk about changing it. So we basically have two separate bodies of law. We have funeral law and we have cemetery law, and they're just structured differently. Funeral law is largely organized around occupational licensing. So the way occupational licensing structures work in general is an activity is defined by the state in a statute, in this case, the practice of funeral service. And then the state says only people who have a particular type of license can engage in those activities which are defined under the statute, right? And so the states are fairly evenly divided right now between so-called single licenses and dual licenses. So in a single license state, practice of funeral service is defined, and to act as a funeral director or embalmer, there's just one license that you can get. In dual license states, which again is about half the states, you can either be a funeral director or you can be an embalmer, right? So you can't practice embalming without an embalmer's license, but in some of the states, there are less requirements in order to get a funeral director license, which wouldn't allow you to embalm, but would allow you to do other activities that are sort of defined as funeral directing. So there's really a continuum of licensing requirements from state to state. But in general, to get one of these licenses, what you have to do currently is attend a school that offers an associate's degree in mortuary science and funeral service. There's an arts component and a science component to that degree. There are 3 states that require a bachelor's degree in that, but in the vast majority of states, all the rest, it's an associate's degree. And so that education involves classes about arranging funerals. There's a course in funeral law, and then there's a lot of restorative arts and embalming that takes place in that curriculum as well. After you get your degree, or in some states while you're working on your degree, you serve an apprenticeship with a private sector funeral home, if you can find one, which can be a challenge in some states, right? Especially that are suffering from sort of population losses. And then you have to do a minimum number of arrangements and a minimum number of embalmings during the course of that apprenticeship. Then you have to take an exam, a national board exam, which is both on the art and the science. So you have to have taken the classes, you have to have practiced the arrangements and the embalmings, and you have to take a national exam, which is a difficult exam. And then in the state that you want to get licensed in, you also have to take a test on the state laws, which as a law professor, I'm on board with that, that particular requirement. So, but the point is that this entire regulatory system, which was developed at the end of the 1800s, beginning of the 1900s, is based on the assumption that people are going to be picked up soon after their death by a funeral home, taken to the funeral home. There's going to be an open casket viewing of an embalmed body. That body will be taken in a casket to a cemetery and buried in a vault. So we would call that embalming and casket burial, okay? So with some financial support from the Order of the Good Death, I did a consumer survey, which will be published in November. I'll give you a little sneak peek about what we found out in our survey. We asked people, we gave them 6 methods of disposition and asked them, would you consider this method of disposition? And then we asked them to rank order their preferences. And then we asked a couple of questions about embalming. When we ask people to rank order their preferences, only 21% of the folks said that casket burial is their first choice. Casket burial is the absolute foundation of the entire regulatory structure. Then we ask people, would you consider embalming? Because embalming isn't a method of disposition, right? It's part of the process. Would you consider embalming for yourself? 37% of the people said that they would consider embalming. And this is a survey of I think the youngest were 18 and the oldest were 80. So it was a real cross section. We didn't see a huge amount of variety from generation to generation. But people are, I think what this showed is people are increasingly rejecting embalming and casket burial, which again are the foundations of the entire system. So I think the time is ripe. You know, people want to get more involved in death. As many of you have that experience, right, of being involved in different ways than the traditional services that funeral directors offer. They want to look at new methods of disposition. And so I think this is really a great opportunity to take a look at the educational system, the licensure requirements, et cetera, and to see how we can break it down into more of a dual track system in every state. And why make people go through all the training for embalming? Why make them invest in all the technology to offer embalming if only 37% of the American population is even willing to consider embalming, right? That makes no sense. You're just adding expense to the whole system. You're keeping people out of the industry who want to really add value in ways that consumers increasingly want. So I'm not saying get rid of everything. There's still people who want casket burial and embalming. That's fine. I think people should have their choices. But I think that there's a lot of evidence that the time has come that we need to open up the industry, starting with the law.
I'm Ben Field. I'm an attorney at the Institute for Justice, and I'm kind of going to pick up where Tanya left off with a couple case studies of how these sort of antiquated and overly onerous regulations affect everyday people. And so the Institute for Justice, for those who aren't familiar, we're a national nonprofit law firm. We represent all of our clients pro bono. And two of the big things that we care about are protecting people's ability to earn a living by doing an honest job without unnecessarily burdensome regulation, and also protecting people's free speech rights. And those really came to a head coming together in defending two groups of death doulas. And so the first is Full Circle of Living and Dying. This is Akila Murphy, who is with us. So I hope that she's wonderful. You should say hello to her during a break. And Donna Pizer. So Akila is the founder of Full Circle, and Donna was one of the leaders when we launched this case. And so they were death doulas in a volunteer organization, a nonprofit. And they sort of did three sort of general categories of things. One of them was public education about end-of-life care. One of them was helping people come up with individualized end-of-life plans. So, you know, you'd sit down, as so many of you I'm sure have done, with a person who's, you know, potentially close to death and their family to figure out what they want. And then finally, they would also help people perform home funerals. And so do things that were completely legal for families in California to do, but that most people have not done. So, you know, most people have not experienced putting ice packs around a body, or don't necessarily know, you know, moving a body is a little bit different from other types of weight. And so just having somebody who's used to that helping out. But one day they get a call from the state funeral bureau who says, well, you need to be fully licensed funeral directors and have a funeral establishment, a funeral home that you will never use in order to do this. And they went in, they said, surely we'll like explain what's going on to the bureau and they'll be reasonable. And I think that's probably a good introduction to the next slide. So here's what the definition of funeral directing is in California. And I think this is a good example of just how broad and capacious these laws can be. So if you you could squint at this and think that it's kind of reasonable. It's like, oh, it's like getting at things that like seem like embalming or casketing. And if the Bureau interpreted it that way, that would be entirely reasonable. But you could also read it to be entirely circular. So, you know, subsection A is essential, or subsection B rather, is essentially funeral directing is directing a funeral. And that is indeed how it's interpreted. And so we deposed the head of the Bureau, the deputy head of the Bureau, and their frontline investigator. All of them gave different answers for what they thought constituted funeral directing. And the frontline guy, the one who wrote the citation to Akila, he thought that essentially anything having to do with death was funeral directing and required a license. And so that's how it worked. And you can see at the bottom, it said that like they were even offended that Akila was using the word home funeral guide. to describe herself, and they thought that violated the last provision. So that wasn't great. So let's go across the country to Indiana now. Let's go to the next slide. So this is Lauren Richwine. So she is sort of a solo practitioner, death doula, who runs an LLC called Death Done Differently. She's in Fort Wayne, Indiana, Northeast Indiana. And her practice is entirely just talking to people. Indiana has some of the most onerous funeral regulations in the country. They require anybody who dies to get a funeral director, to hire a funeral director. And her service is entirely complementary to that. And so she just like talks with people, gives them advice on grieving, gives them advice on planning for the end of life, all the things I'm sure you all are so familiar with. And she got a letter from the Indiana Funeral Board. If we can go to the next slide, here's the statute in Indiana. So the statute in Indiana is incredibly capacious. It just directly regulates speech by saying if you're counseling people about death, that requires having both a funeral director license and a funeral home license. And then this last provision I think is particularly bonkers because it says if you are complying with the law, you are practicing funeral directing. So it seems like everybody in Indiana needs a funeral director license. And so, Lauren like wrote a letter back to the board, with testimonials from some of her clients, from a funeral director that she works with frequently, explaining that what she does is not funeral directing, but the board had no interest in that. And so I think the thing that links into what Tanya was saying is like you can see how capacious these laws are, and if they're being applied sensibly by sensible people, it wouldn't be that big a deal. But unfortunately, the way that a lot of these boards and bureaus work is they just like the people in them are licensed funeral directors or former funeral directors, and they kind of just have this model in their mind that every single person is going to be embalmed and have a casket burial, and anything that looks remotely like that, they think needs to be within the license and regulatory scheme. And so sort of where I come in is that obviously the best frontline response would be for the states to just be reasonable about how they're applying their laws, or to write laws, like Tanya's saying, that are actually tailored to, I think that we can all agree that if you're taking custody of a loved one, of their body, and you're embalming them, that there probably should be some regulation around that. But there's no reason that that should sweep in just talking to people about planning for the end of life. And so there is a constitutional backstop, which is where I come in. So if you go to the next slide, most of you are probably familiar with the First Amendment to the United States Constitution, which says government shall make no law abridging the freedom of speech. And so in both the Full Circle case and in Lauren's case, we brought First Amendment claims on their behalf, saying insofar as what they're doing is talking to people, that is fully protected by the First Amendment, and the government needs a very, very good reason in order to take away that right. And so in the Full Circle case, we won that claim completely. And in Lauren's case, that is still going on, but in the district court, which is the lowest, that case is now up on appeal, which should be heard sometime in the new year. And then second, next slide, is the 14th Amendment. So this is a little bit more complicated, but basically, no matter anytime the government is regulating you, there's at least a minimal backstop that it has to be rational. And it is so the First Amendment is like kind of, a big club that if the government's trying to stop you from speaking, you have like a very, very strong legal claim to come in and defend yourself. Unfortunately, if the government can say it's conduct rather than speech, it's your protection is much weaker. So in Akila's case, there's this distinction when she's talking to people to plan for the end of life, that's speech. And so that's fully protected. That's the First Amendment. But when it comes to like actually physically assisting at a home funeral, courts treat that as conduct. And so it gets this much lower protection where all the government has to show it's that's rational. But in Akila's case, the government wasn't able to do even that. And so we also almost entirely won our claim under the 14th Amendment for her ability to help people perform a home funeral. And after that, the government sort of threw in the towel, and the few parts that we hadn't yet fully won in court, California agreed to interpret their regulation in the way that they should have done from the very beginning, which is that Akila and her colleagues do not need to be funeral directors and to own a funeral home in order to do what they're doing. No death doulas in California who are running into trouble with the Bureau, let me know, because we would love to make sure that Full Circle's victory applies to them too, which leads to my last slide, which is just, again, if any of you do end up getting a call like Akila or like Lauren got from your funeral board or your funeral bureau, because you're just helping people plan for the end of life, send me an email, come up to me during this, and I'll give you my card. And hopefully, hopefully, litigation is at least one tool to get the government to behave reasonably in this area.
Well, thank you all for being here this morning. Is it? Yeah. It's right here. Can you hear me okay? No. Here? Yeah. So thanks for being here today on a Saturday morning. And I just want to say thank you for all the work that you're doing. So many people aren't present or can't be present for whatever reason when someone is dying. And so I just want to first say thank you for being there for people in some of their most tender and vulnerable times. That's not an easy thing to do. So I am the founder and executive director of Evermore, which is a nonprofit advocacy group. And in fact, probably the only one in the United States. I'm a little bit of an oddball on this panel. I'm not an attorney, more of an activist who believes right now, I will say, across about a dozen federal agencies. And so part of my work in the last couple of years has been integrating bereavement and bereavement care policies across the US federal government. And you'll start seeing some of the manifestation of that probably in your own practice. And some of you who follow our work are already well aware of that. We've gotten some things done via appropriations. Health and Human Services is doing a lot of work. SAMHSA is going to start weighing in on this. The US Department of Education has changed the FAFSA to include orphanhood. There's a number of other things happening, but that's not what I'm here for today. What I'm here for today is, I think, our comments that we submitted to the FTC regarding the funeral rule and price transparency. And, just inherently what drives us is that there should be clear and transparent pricing information offered to all consumers, full stop. There's obviously a lot of history, and I will defer to my colleagues who are much more distinguished than I am in all the machinations of the policies or how they came to be. But in this day and age, you should be able to, as you do, you go buy a coffee and know exactly what it is that you're buying. And we believe that you should also be able to do that in the funeral home space, and that the lack of pricing transparency is really quite problematic, because grief and bereavement specifically, so grief being the emotional response to a loss and bereavement being the event, that bereavement itself is a highly vulnerable time that can actually serve as an initiation event for people to now become at risk of other public emergencies. And so how do we in that time begin to build systems of support around people, including financial systems of support? I'm not going to get into SSA policy today, Social Security policy, but please hit me up after. There's some very important things happening at the Social Security Administration right now around financial solvency. And so our comments to the FTC were really around these parameters, that right now in the United States, we have a concurrency of mortality epidemics from homicide, suicide, overdose, maternal mortality, traffic fatalities. And of course, we also have people dying of old age. In recent years, we've seen premature death or the longevity of an individual in the United States decrease, which we haven't seen since World War II. Coupled with that, we've seen record revenues from the funeral industry. Again, under this cloak of price transparency, we're not here to regulate what they charge, but we do believe rather that you should be able to see, you should be able to see what they're charging as well as a consumer. So here, I don't know how many of you, this was actually, I was on my way to the grocery store one day, and I think this kind of, this kind of public display for compassion to support a funeral, I don't think that this is right. We also see in the concurrency of these mortality epidemics a disproportionate burden on people who are Black and brown. And not only is it just a disproportionate burden, but unexpected and early death tends to have a predominant and disproportionate burden earlier and more consistently for Black and brown individuals, meaning that they are incurring these high costs. And according to NFDA, the average price of a funeral or funeral and cemetery, so forth, between $7,000 to $10,000, $12,000, somewhere in there. Now imagine for many of us who have, let's say, a 401k, where early in life you're investing your money in your 401k and you are building up those funds over time that are compounding. If you are hit with this unexpected expense of $7,000, $10,000, $12,000 earlier in life, that is relegating you to economic instability. And again, not believing that this is the way the system should be constructed. And I'm sure all of us, or I'll ask, how many people here have seen a GoFundMe page to support a funeral? Yeah. Did you know, according to the Federal Reserve, more than a third of Americans cannot afford an unexpected expense of exactly $400. So we are not just, people are not just sad or experiencing sorrow. They are in a very tender moment. And we, as fellow people in America, should not be, I would say, kicking them while they're down or trying to take advantage of them through fuzzy math, if you will, during these times. It should be clear, it should be transparent. And if I could just go to the next slide briefly. The Wall Street Journal did 2 investigative reports about this. The Wall Street Journal leans towards corporate America. And I was actually quite surprised by this. Not only did the journal sort of highlight this, but they began to reshift some, I think, politics around the FTC. In that, when we submitted our comments, the FTC wasn't asking what we thought about FROP, the Funeral Rule Offenders Program, which effectively, when a funeral home violates the pricing structure and they get caught, they get referred into FROP. FROP is actually run by the Lobbying Association for the Funeral Industry. So you as consumers could never even see who had violated the funeral rule. And I will tell you, when the FTC asked for public comment, the one thing they said was, don't talk about FROP. Well, I couldn't resist, I have to tell you. And so I had some additional comments around FROP because that needs to be restructured. Next slide, please. What they did is they FOIA'd, Wall Street Journal FOIA'd the FTC. So there is a list on the Wall Street Journal website of all the 500 plus funeral homes in America that have violated pricing. Next slide, please. So just to know that as a resource. Also, they did another, they did another article, and I'm sure they talked to some of you in this room. They did call me about, how should people pay in advance? And I'm certainly not an expert on that. But what they ended up finding was that you really shouldn't pay in advance, and here are all the reasons why. And so that's also another very interesting story. And I think that that's my last slide, maybe not. So that is the work that we're doing. The FTC is probably going to make a ruling sometime soon. No one actually knows. I suspect that they're going to make a ruling to, try to increase price transparency. And I think that they're going to get sued pretty quickly. The FTC has already been under scrutiny for their internal regulatory processes. And there has been unanimous Supreme Court opinions to this matter, that one in particular that was written by Elena Kagan. So it is very likely that the funeral rule could come out and be more strict. And then it is very likely that they will be sued and that the FTC will be stalled in that attempt to increase price transparency. So thank you all for having me here today and being a little bit of an oddball on this panel. Thank you.
Okay, you can go to the next slide. It's great to see all of you this morning. My name is Kevin Díaz, and I'm with Compassion and Choices. We're a national nonprofit that works to improve care and expand options at the end of life. And today I wanted to talk to you a little bit about what the state of the law is as it relates to people who presently do not live in a jurisdiction that has authorized medical aid in dying. How is it that they can access it? Because there have been some changes recently. Next slide, please. To start off, I wanted to just draw a baseline about what medical aid in dying is. So it is a medical practice that allows terminally ill, mentally capable adults to request medication from their physician to self-ingest to bring about a peaceful death. Next slide, please. It is not euthanasia. So I want to make that very clear. And it is not what people call medical aid in dying in Canada, for example. In Canada, it is a much broader practice, and that's because of the different Supreme Court decisions, both in Canada and the United States. But in Canada, for example, it is euthanasia. It can include euthanasia. It also can include people who aren't terminally ill. It also, as a legal matter, isn't assisted suicide. And this is a really critical point. Our opponents oftentimes are saying that it is assisted suicide. Assisted suicide is a crime. It exists. It is different than medical aid in dying. In every single jurisdiction where you have medical aid in dying, there are also criminal sanctions against assisted suicide, which is outside of the medical context and usually involves something around goading and or providing material help to further someone who's in a mental health crisis to take their own life. I also really want to stress, this is really important because I feel like sometimes people think of Compassion and Choices and only medical aid in dying. And medical aid in dying is an important option. We believe it should be one of many options, but it is not the end all be all for all people. And the thing that is so critical is that people are able to die in a way that matches their values and priorities. It's 11 right now. We almost had 12. Unfortunately, the governor in Delaware just vetoed a legislation that we had helped pass, but we'll keep at it. Next slide. Residents of any state can legally access medical aid in dying. Any state. Now, how do you go about doing this? Next slide. There's the traditional way, which is you have to become a resident of an authorized state, because one thing that is incredibly odd to me is that as far as I know, I can't think of any other medical practice that you are categorically barred from even applying for or engaging with solely based on your zip code. If you are a resident to another state where it's authorized that you saw on the map there, and you would have to legally change your residence. And oftentimes the way people would prove that change in domicile is through a driver's license or showing that you have a rental agreement, those kinds of things. That is obviously an additional burden for people who are in the process of dying. If you're have a serious disease or you're terminally ill, the idea of taking a driver's test isn't particularly appealing. It was never appealing even when we were 18 and perfectly healthy. And then, it's also an equity issue in many ways, because who has the means to be able to go and get another residence, a second home, essentially, because oftentimes they might not be able to necessarily sell their legislation that we brought in both Oregon and Vermont, and then the legislature subsequently in compliance with, well, the legislatures didn't sign the settlement agreement, but the departments within those states agreed to support legislation to remove the residency requirements for those two states. And so that's really important because you don't have to jump through those additional hoops. And what's more is, for folks who might have complicated estate planning documents or other kinds of things, they don't have to worry that, oh, if I suddenly change my domicile to this other state, now all of a sudden I've got to redo all my estate planning documents. Next slide, please. It is one thing that, as much as we would like to have medical aid and dying authorized in every single state, we think that's the best solution because we think people shouldn't have to move or travel to obtain this particular option. The truth of the matter is right now, to receive the full protections of the law. So if you go to Oregon or to Vermont, or even if you're in a resident in an authorized state and you're going through this process, to receive the full protections, you really must have all of the aspects of medical aid and dying take place in the state in which you qualified. That is the safest thing for the patient, it's the safest thing for the clinician, and it's the safest thing for the loved ones or family members that might be with somebody when they decide to self-ingest the medication. Next slide. And of course, there are practical considerations that people should be thinking about when you're advising people about whether or not this is an option that they might be able to pursue. So travel is a huge issue for terminally ill people. That's obviously going to limit the availability of this, but if you do it ahead of time, it might still be possible. And then I think one other thing that's really, really critical is that people understand that it's not just, you're just not going to the state to obtain medical aid and dying. You're really going there to have that option available. It's still critically important that you have your care team all set up, that you're enrolled in hospice care, all of those things. You don't want to just go and then all of a sudden think that you're going to go through the process so quickly that you're going to get the medication and use it. One of the statistics that I always find really interesting is that the high percentage of people who actually obtain medication but don't actually use it. And that's a testament in many ways to their hospice team and the fact that they never reached a point where they felt they needed to use it. And we want to keep that we want that to be true. We don't want people to feel forced into using the medication. Next slide. Lastly, I wanted to point out one thing that has become more salient recently with the debates around reproductive health care. So there have been more and more attempts to limit people traveling or helping people travel to obtain reproductive health and so healthcare. And so if you're talking to someone who might be coming from a state where that's a really hot issue, one thing that we always advise is for people to consult with a local criminal defense attorney to get a read of the local prosecutor, to understand their specific laws, whether or not they could be charged under that state's assisted suicide statute is something that usually takes some legal research to figure out and some analysis of case law. And the thing, it's also a political question in many ways, because what happens is, a prosecutor can bring a charge and that's going to really undo a lot of what that patient is seeking because they're at the end of their lives, regardless of whether or not I think we can actually beat that lawsuit or that criminal charge. So an additional layer to think about. And the last slide. I also just want to make sure that if people haven't visited our website, that they have the opportunity to do so. We have packets on every single authorized jurisdiction that will go through all the steps, the things that people should expect. They're all free. Feel free to download them and use them, as well as a number of other really valuable tools that people can access to help identify what their priorities and goals are for their end-of-life care. Thank you so much.
All right, I want to start by asking, do any of you have follow-ups for each other after that initial, spiel that we all gave? Because if not, I can go ahead and start asking follow-ups. Okay, so what I would love to understand is how can people in this room and people watching online drive towards a more effective system when it comes to the legal landscape in death care? Like, I feel like Joyal, I feel like for the FTC, I feel like I have a grasp of like what people can do when it came to like, sending in public comments. But like, for example, you know, is there something like Ben, for example, that people could do around trying to advocate for clearer, less capacious laws on a state level, right? Is that something that people can do as individuals, or does it require a lawsuit for that to happen?
So it's definitely something that individuals can do. And I think that, I mean, I think one feature of like nationalizing our politics is that people like are always focused on, you know, who's running for president. Whereas in reality, as Tanya was talking about, like these laws are entirely state by state at the state level. And so if you just like write a letter to your state legislator, you know, they're probably not hearing from that many people who are interested in this. They're definitely hearing from the licensed funeral industry who are trying to protect their business. But if you get wind, so for instance, if you live in Colorado, it's one of the few states that didn't have funeral licensure, but because of some scandals, which actually involved licensees from other states, they're passing, you know, they're probably going to pass funeral director licensure. And they did. Okay. So if you're in a situation where you know that your state house is like considering to make funeral licensing more expansive, you know, write a letter, pick up the phone, make a call. That can certainly have an effect. And I think like if you do, you know, obviously for your individual practice, you have to decide what's right for you. And to a certain extent, flying under the radar, I think is what most, you know, death doulas do. And it generally, unless somebody, the way that all these enforcement agencies work is they're complaint driven. So if nobody complains, there's no problem. But if someone does issue a complaint, you know, consider fighting back. You know, stand up for yourself. If you have the resources, hire an attorney. If not, give me a call, because we're very excited to have more of these cases. Akil and Lauren are two of my favorite clients. But, you know, at every level, I think you, by standing up for yourself, by making it known that you care about it, that your clients care about it, I think you can push in the right direction.
Isabel, can I add one thing to that? I think we've seen changing the fundamental structure of the occupational licensing system is a difficult thing for individual action, right? I mean, that's going to take organization and lobbying on a state by state. It's going to be a slog to try and get that done. However, this is my, I think, the good news thing. Natural organic reduction did not exist 10 years ago. It is now legal in 12 states. And I think what is really amazing and sort of inspiring about that is that it was not, I mean, the first couple of states, you know, Katrina Spade worked really hard to get legalized in Washington state, right? And that took a lot of effort. And there were people in this room who were very cooperative in that effort. So it wasn't like a solo endeavor. But there are states where it went up to the legislature and got legalized, and nobody who currently offers these services is involved in the industry. Like, nobody was involved. Those were 100% consumer driven efforts to get it legalized in a number of states. That's really amazing. I think, you know, to Ben's point, legislators are not used to hearing from the public about anything involving death care. And so when they do, that can be really impactful. And especially if there's an organized effort that they're hearing from a lot of people who are all aligned in terms of what kind of change they want to see, you can really make a difference.
And I'll just dovetail on that. I think educating your state, local, and federal lawmakers is very important. I'll tell you, on Capitol Hill, for every one call that is registered in the office, the loose number is about, that represents the views of about 100 people. So your one call, they think 100 people are at least thinking about this. So if you organize locally and grab 10 other people to make 10 other calls to follow you, you start, you start having people listen to you and start to understand and educate this en masse. The other thing that I would just encourage you to try to hold on these sets of issues is not walking into the conversations with a partisan lens. And I know that's incredible. I can appreciate how incredibly challenging that is. But because this issue is in so many ways is nascent, there is really quite eager ears on both sides. And so, and I would also just add sort of the family element and preserving family values and the solvency of people is something that resonates. And so I would just encourage you It might be a little intimidating to pick up the phone and have those first few calls, but if not you, then who?
I had one thought from your comment, and then also what we were talking about backstage beforehand, which was this patchwork that exists around the country, and to what extent like the Uniform Law Commission or some other entity could put forth some sort of guidelines that say don't violate the Constitution, that have the best language, and that, you know, have really listened to all the different stakeholders and have, you know, that kind of expertise come together and promulgate something. I don't know if that's been done before or tried before, but it certainly seems like, based on what I heard, that it might be an option at some point.
I would love for the Uniform Law Commission to be interested in this. I propose, this is a little in the weeds. If you execute a will in one state and then you die in another state, that other state has a law that will recognize your will. Okay, so that's true in all 50 states. If you execute a designated agent form or a funeral preferences form in a particular state, you better hope that, and then you die in a different state, you better hope that state has the same requirements for witnesses or notaries or exact statutory language as the state where you execute it, or they will not respect that document. I went to Uniform Law Commission twice and proposed that we take the same laws that just respect wills and apply it to designated agent and funeral planning documents, and they won't pick it up. I thought that was about the most modest change in the law we could possibly ask for, and I couldn't get them interested in that. So I think I would, but you know, let's start. I mean, you know, it might take 20 years, but let's work on it.
Well, I mean, so Compassion and Choices does a lot of this kind of advocacy, and I'm wondering like how you then sort of come up with prioritization for like how to get those. Yeah, how do you strategize around like who you want to focus on when it comes to that? Because like obviously it's a lot easier to do this kind of advocacy in a structure as opposed to individuals trying to go themselves, even though that's something that they should definitely do, right?
Well, for us, the first step, of course, is tying everything back to our mission. So we're really patient focused. And then, you know, when it comes to resource allocation, we look around the room, we see who else is involved in certain kinds of things, how we can be of most benefit, and push things forward. And we do have expertise in some particular areas, and so we try to leverage those as much as possible. But as opportunities present themselves, we it's in that area, and we have a little bit of a different lens, of very much a patient focused lens that we can then add to the conversation. And so part of that process also is listening to our supporters, listening to our funders, and listening to our staff to understand what opportunities are there.
Thank you. Does anyone here on the panel, before we go into the discussion piece, have any other thoughts around like this question of like, okay, if you could design your ideal legal system around, you know, death care, what that would entail? If there's anything that you want to include that you haven't already spoken about?
The only thing I'll mention is just the strategic piece, which I think that we've sort of touched on a little bit. I think that if and have, you know, are going to the legislators with common language and a strong focus. You know, I think that a bunch of people randomly calling legislators and asking for radically different things shows there's interest in death care, but isn't going to be particularly effective in advancing an agenda. So I would just suggest, I think it's great to have a lot of coordination, but we just need to be, I think, targeted about it. And the more targeted, the more efficient and effective we'll be.
And I think that the general principle guiding it, I think state by state, it would, you know, vary what you coalesce around to push for. But I think that the general principle should be that rather than starting with a top down, like we're going to envision how we think the entire industry should be and come up with a series of regulations to force people into that uniform bucket, be narrowly tailored to that. So I think that if somebody, whether a funeral director, an embalmer, or a cemeterian, if they're taking physical custody of a body, position of intense trust, and there is potentially reasonable regulation around that. Embalming, there might be specific regulations around making sure that people know what they're doing for that. But for a death doula, like I think, frankly, my position is that I don't think there should be licensure of any kind. Like you're just talking to people or giving common sense advice. And I think there can absolutely be private certification. So like NIDA, like ANELDA, so that clients can know you have this expertise, but there's no reason for the state to impose a one size fits all. So I would just say that for each service, just think about what is sort of the least restrictive means necessary to serve the public interest. And let's not go beyond that to impose prophylactic regulations that really ultimately just get captured by the industry.